Our next question is from Stephanie via text. Do I really need more than a basic will? What are the biggest mistakes people make with estate planning that I should be aware of? Great question, Stephanie. Estate planning, a big piece to your retirement plan. First of all, we're not attorneys. We need to put that out there front. So if for legal advice for you specifically, you do need to reach out to an attorney. But we can talk about the pros and cons of different elements of estate planning, because she starts off by stepping into, do I need more than a basic will? And we like to say a will is better than nothing, but it's not much better than that.
Yes, it is a ticket to probate.
That's right.
You know, I will tell you guys, when I first started on my journey as an advisor, meeting with clients and people would talk about estate planning, I felt like there were a lot of people that I would go, you don't need an estate plan. You don't have a lot of assets, no big deal. Until I experienced it myself and I had to probate my parents' estate, and it was a nightmare. It took so much time. And I think that's the thing people don't realize. It's not just about financial expense. It's about the time spent on the person who's responsible for all those steps. And the will, it was minimally helpful for me. All it did was label who gets to do all the work. And at the end of probate, what I needed to do with the assets. So be very clear that is not what really, really gets the job done. But there are a lot of other things that we have seen that can be, you talked about kind of the worst mistakes people have made, some other mistakes that we've seen that are equally as difficult as not having a really well-planned estate. Yeah,
so we'll get into a little bit more color on what you need to consider if you need more than a basic will in a minute, but she does ask, what are the biggest mistakes people make? And I think the number one for me is not updating beneficiaries during major life changes, divorce, a death. Grandchildren get into the equation there, and that may not mean that you put the grandchild on as the beneficiary, but do you think about how you want to run through your children to the grandchildren, meaning the difference between per stirpes and pro rata. That's a big one that people forget about, and we'll just explain that a little bit. So if you think about, obviously, divorce, if you're not married to the person anymore, you need to probably change the beneficiary, unless you want to give them all your money. That's obviously up to you.
And especially if you remarry. We've had some fun conversations.
You don't want to be in the financial advisor office before you realize that your ex-spouse is the beneficiary of your accounts. Obviously, if there's a death, you need to be making appropriate updates there. But this pro rata per stirpes thing, and people think I'm talking another language. I really am, technically.
You are.
I think that might be Latin. Most people will check the box on pro rata. So let's just walk through how beneficiaries work. So generally, you're going to have, if you have a retirement account, your primary beneficiary is going to be your spouse. You're going to leave 100% of your assets to your spouse. And then your kids, if you have some, are likely going to be the contingent beneficiaries. When you set that up initially, your kids may not be married. They may not have children. They may be just getting started in life. And you lay that out pro rata, meaning that if you have 3 kids, you might split that up a third, or really 34%, 33%, 33%, because we can't put decimal points in ours. Somebody gets 1 extra percent. And if one of those children, for some reason, predeceased you prior to both you and your spouse's passing, which is obviously not going to be common, but it could happen, then their third share would then be split among the remaining 2 kids, which is fine if they don't have a family. But then when you get to them getting married and having having children, and they're your grandchildren, and you want to make sure those grandchildren get that, per stirpes make sure that it goes through their line. So in this case, if one of the 3 children was deceased upon both of your passing, their share would be passed on to their children. So it's a great consideration. I mean, that's something that can really slip through the cracks for sure when it comes to updating beneficiaries.
Yes, and it's something to discuss, just like we talked about with Medicare and those looking at it annually. It's always good to once a year have a conversation with your advisor and make sure that everything is as you want it. And there are other types of beneficiaries. So if you're not retired yet, making sure your employer plan is up to date every single year, reviewing it just to be sure you didn't miss something.
Yeah, and I think the big mistake that people can make is they create the trust and then they're done with it, and they don't actually fully fund it. So we talked about beneficiaries being the kids. If you do build a trust, create a trust, you're likely going to want that trust to be the beneficiary of the account, or how are you going to fund it? And that's one of the things that slips through the cracks sometimes when people are creating some estate planning there. And then when you think about if you do have a trust, what about the deed to your your home. The trust is going to typically own some things when you are alive and then be a beneficiary of some things and won't be actually funded with those until after you die. But the house is one that I think people really can slip up on if they're not paying attention.
Yes, in some cases that trust documentation becomes a really expensive book in your library.
Yeah.
And so you really want to make sure you look at the homework page and you do all those follow-up tasks. But I've seen this issue with the deed on the home be a problem even outside of some people who have estate planning. I have, in the case of my house that I had in Benton, the financing was through me because at that time my husband was finishing college. So the financing had to go through me since I already had the job. But we were very careful to make sure both of our names made it on the deed. I recently had a situation where I was witness to what happens when that doesn't happen. There was a client, they bought the house. This was a second marriage, so he already owned the house. His name was the only one on the deed, and he passed away. Well, now she is only a partial owner of the house she's lived in for over 12 years. So it's really important to make sure that even if only one of you is on the financing, both of you are on the deed. And then once you have that trust, make sure the deed is rewritten, retitled to the trust, or that you have a beneficiary deed so that it flows through like you want it to, and there's not all that chaos that happens otherwise.
And we've been talking a lot about the will versus the trust, or what the trust can provide. Certainly the trust is about making sure your wishes are carried out the way you want after you're gone, distributing wealth to the kids if there are special wishes for the kids, or funding college for the grandkids. The trust can protect the next generation even from divorce and lawsuits. Not everyone needs a trust, but certainly talking to an attorney and determining your need is very important. But the estate planning packet, that big folder that you're going to have, or that binder that you're going to have, is going to have more than a trust and a will. You'll also be needing things like a power of attorney and healthcare directives. And Teresa, those are sometimes just as important.
Yes. So before I lost my bonus dad, he was in the hospital for a very long time. And so I needed to be able to take care of his assets for him while he was down. And I had power of attorney. Thankfully, they had done durable power of attorney. There are different types. There are those that only come into play when you are deemed incapable of taking care of things yourself, so you're incapacitated. There are those that are immediately active. So depending on what your family needs, it allows that person, while you're still alive, but maybe you're not able to take care of yourself, it allows them the power to help you during that time. Now, the thing I found out later was once they pass away, it's no longer active. And that one kind of shocked me. So there's that one for you. The healthcare directive, I would have loved to have had that. Some call it a medical directive. I would have loved to have that prior to my dad's surgery so that I could have known what his wishes were, because we did get to a point where I had to make decisions that I didn't know what he would want. And that's all it's doing. Whether you want supplemental nutrition or you want life-saving measures, it gives your family the freedom to follow your wishes and it not be on them. So for instance, if I'm the one that has to make the decision to withdraw life-saving measures from my parent, and I have this document that says, well, that's what they wanted, and I just hand that to the doctor, it's genuinely not me being put in the position of guessing.
Yeah.
And so it is really critical to have all of that documentation lined out and then make sure the people who need it have access to it.
The biggest mistake, though, we see people make when it comes to estate planning is not doing it.
Yes.
Don't put it off.